was not given when it was raised. I think we needed to relook at the legal provisions, and we think it should be given now so that it goes on record. The position is that Section 43 of the Bank of Uganda Act, which provides that the bank shall not publish or disclose any information regarding the affairs of a financial institution or its customer unless the consent of that financial institution or customer has been sought, has exceptions. Mr. Chairman, if you look at Section 133 of the FIA, that section overrides Section 43 to the extent of 133. Mr. Chairman, I wanted to read the section. It provides that for purposes of any matter concerning financial institution, this Act takes precedence over any enactments, and in case of conflict, this Act shall prevail.
Yes, I've seen it.
Yes, and Mr. Chairman, therefore, our view is that the FIA is a law of specific application, while the Bank of Uganda Act is a law of general application. If you say that Section 43 overrides the FIA in all respects, then some provisions of the FIA will be rendered null and void. And we do not think that was the intention of the legislature. One such provision that has become nullified is Section 78. Section 78, under that section, the Bank of Uganda can license credit reference bureaus to share information about its customers. Another section, Mr. Chairman, is Section 80, subsection 5. That section allows the central bank to share information with monetary authorities. Other monetary authorities. Another section, Mr. Chairman, is Section 821B. That section allows the central bank to appoint an agent to go into a problem institution and come up with resolution options. Our position, therefore, Mr. Chairman, is that since resolution is part of the discharge of the functions of the Bank of Uganda under the Financial Institutions Act, a disclosure intended to manage a resolution is accepted. In addition, Mr. Chairman, there are other legal exceptions to that Section 43. For instance, the court can order the central bank to provide information, and it would never be able to cite that section and not provide the information. And in addition, Mr. Chairman, in a resolution, there cannot be a seamless transition of depositors. There cannot be a seamless transition of depositors if where they are going is not known. You have at least three options. One, you can close the institution and wait, and as you seek bids and deny depositors access to their funds for that entire period. The other option, as pointed out by Mr. Katimbo yesterday, is that you keep the institution open and depositors can access funds, but in that case, the central bank is guaranteeing the obligation of that institution, meaning that if the obligations as they fall due must be settled. And with regard to the first option, which says that you close the institution and wait until you get sufficient bids or people competing, that means that you can trigger a run on other institutions. In addition, you deny depositors access to their deposits. The other option of the central bank is to create a seamless transition. So in resolution, if accepted, and the provision backing it is section 133. Now, Mr. Chairman, you also say that if we don't agree that this section is paramount, court can order production of that information. And Mr. Chairman, most recently, the committee ordered us to provide that information, and it was provided. It is about existing customers and running banks. Thank you.
Yes, I have listened, and I hope counsel of the committee has listened. I don't want this to be a debate. We are going to peruse the law again, but I have one or two points to make. One, when a law prohibits you to disclose, they are what we call authorized disclosures by other laws. For example, if you have been ordered by a court of law, because it has that inherent legal right to order for production, you cannot plead section 40, because that is an unauthorized legal disclosure. If you have been ordered by a committee of parliament, it is under Article 9 of the Constitution. That is authorized legal disclosure. So it is wrong for counsel to start citing what we call authorized legal disclosure and obligation to relate it to other disclosures. That is absolutely wrong. Two, you have other monetary institutions which you do it for purposes of fulfilling your mandate. It is authorized legal disclosure. What we are talking about is even what Mr. Katimba explained. The reason why under the FIA you were given powers to statutorily manage, and once you move in, you extinguish the rights of the shareholders and directors, is to provide that transition. You become totally in charge of a financial institution. Totally in charge. At that point, you can also do even disclosures, because the directors and the shareholders' rights have been extinguished by the law. So you can do the disclosures, you can invite those confidential acquirers, and at that point you can do it. However, when a bank is still in the hands of the owners, the shareholders and directors, they are protected by the law, except to Bank of Uganda as a what? A regulator. That is my interpretation. Different from what counsel is saying, but we shall govern examine it further. Our view is the Bank of Uganda has been given powers to come in as a statutory manager. The bank is still open when you come in as a statutory manager. So customers can continue to transact or whatever until you take the decision of closure. Two, because you appoint a statutory manager, you go in and the bank operates. And at that point, you can do any transaction you wish, including preparation for sale, because the law has given you that authority. But before you seize a bank under the law, and you are busy sharing this information with other banks, other people who are not authorized, more particularly when they are competitors. More particularly when they are what? Competitors. It raises questions. It raises questions, legal questions. So we don't interpret a law to absurdity. Why? Because the Constitution of the Republic was the copy of the Constitution. Should be Article 40 from. Sorry, colleagues, but we need to sort these things out. You know what we call right to property. Right to what? To property. If the shareholders and directors have got a right to their business property, so you have no right to disclose it. You have no right. Not even every citizen has got a right to information which is in the hands of the state. So I think rights to property are constitutionally guaranteed and their protection. However, when the law gives the Bank of Uganda powers, say, look, at this point, because we think you are not the depositor's interest at stake, then the rules of the game change at that point. And when does that point come? You have right to seize and say, excuse, your right to property is no longer guaranteed. It's my own honest interpretation of the law, differing from that of legal counsel, but we shall examine it further, colleagues, okay?
You've perfectly guided it very well, and what I wanted to say is simple. Where we left it yesterday, it appeared like it was even a one person's show. That even at the management level, somebody didn't have any authority to disclose this information. What is now surfacing, and where I want to get clarification, is that management is accepting that Madame Obagenda was acting on its behalf. Otherwise, yesterday it appeared...
Why don't you, Honorable Kaswant, ask that as a question?
Thank you, Mr. Chairman. So, is management now accepting, Mr. Governor, that Ewanu Bajenda was acting on its orders and instructions, and it was fully aware of all the transactions that took place? That is only when the legal counsel's interpretation can even be acknowledged, not accepted. Thank you.
But maybe let's also, now that you raised these legal issues which came yesterday and you want us to interrogate further, did the person who signed that confidential memorandum, what do you call it, in non-disclosure agreement, did she have authority to commit the bank under the law? I'm sure you have gone ahead, you've examined the provisions of the law. That non-confidential, non-disclosure, is it properly signed under the law? Now that you want us to interrogate all this further?
Secondly, Chair, I would also wish to appreciate which part of the law now gives mandate for you to choose which financial institution to merge or to give an offer over and above others that are in existence.
Let's finish one. Sorry?
I can't answer both questions.
So who can? Because I'm sure they are the ones who have brought up this question. Legal counsel, you have since then looked at the law. One other issue that came was who has got powers under the legal regime to enter into contractual obligations with the bank, or of the bank rather.
Mr. Chairman, since I'm not management of the bank, I will not be able to answer to whether
give us the law first, because
law.
you are yes. Give us the law.
Okay.
Because remember, this issue came yesterday.
The issue came yesterday, Mr. Chairman. That is true. It came in broad terms. But let me just clarify on the section that we read yesterday, which you asked me to read. In that section, it is said the seal of the bank shall be authenticated by the signatures of the governor and the secretary to the board. In the absence of the governor and the deputy governor may sign in his or her place, and the person performing the functions of the secretary may sign in the absence of the secretary. A document issued by the bank and sealed with the seal of the bank and authenticated in a manner provided under this section shall be received and taken to be a true document without further proof. Now, Mr. Chairman, with regard to that provision relates to documents that must be under seal. For documents that are not under seal, the issue is there can be authorization for other persons to sign.
Under what law? Who has the right to enter into a contract on behalf of the bank?
The governor or the deputy governor in his absence, or the person authorized to do so by those offices.
By the what?
By those offices. And Mr. Chairman...
Yeah, I just want to know that. Just read the law.
Mr. Chairman.
And eventually also tell us what documents are supposed to be authorized by the seal.
Which are supposed to be under seal?
Yes.
They are provided for in the Bank of Uganda bylaws.
Yes.
Okay. And Mr. Chairman, with regard to whether there can be a performance of executive functions of the governor, we look to section 7 of the Bank of Uganda, section 7, subsection 8 of the Bank of Uganda Act.
What does it say?
It says that wherever for any sufficient reason the governor or the deputy governor are absent at the same time, the governor shall designate a senior officer to perform the executive functions of the deputy governor and attend meetings of the board until the resumption of office of the governor or the deputy governor. And the board shall appoint from among themselves a chairperson in the period of absence of the governor or the deputy governor. In our interpretation, executive roles include signing documents.
You are aware that coming into force of the 1995 Constitution, the position of governor was created different from that which was there before. So from 1995, the position of governor and deputy governor are constitutional. Are you aware about that?
Yes, I am.
Does that change your view about the Bank of Uganda Act? Can any other law delegate the functions vested in an officer by the Constitution? And remember, the Bank of Uganda Act you are citing was before the 1995 Constitution.
Yes, Mr. Chairman.
Can a Bank of Uganda Act delegate functions of a Constitution office?
Mr. Chairman.
Address your mind to it. You may not have
I
an
need
answer
to address my mind to that.
Okay.
Thank you.
Colleagues, I don't want this to be
Mr. Chairman.
a law class.
Mr. Chairman, something's wrong.
Let us go to the substance. Honorable Tumijuche?
Maybe finally on this, if we ask Madam Bajenda to tell us who legally or illegally authorized her to sign the document, maybe that can also go a long way in helping us to understand what exactly happened. So she tells us who exactly authorized her.
And maybe legal counsel would also bring proof that during that time the governor and deputy were not around, as you have cited there. And then bring that authorization letter my colleague is talking about. Those two will assist us to talk like you.
Sorry, I was really consulting. Then I missed the question, Honorable Yandala. If you may kindly repeat it, please.
What I was saying, what she cited here was saying they can delegate if the governor and deputy are not here. So she could bring us in the documentation showing that at that time the governor and the deputy were not here. And of course the delegation, as the Honorable Mwajuche said, if you bring that, you temporarily maybe make us think like you.
Yes, Chair.
Chair, maybe to add on what he's saying, I believe for one to delegate the other party to act, there must be a document, powers delegating. So there should be a letter that is written from governor's office to Mrs. Bajenda to act on their behalf.
And let me say this, Governor and Deputy, these are your powers. If your staff is going to start exercising powers vested in you by the Constitution, under circumstances which are not explainable, there is a problem. I already have it before they come in, and I was going to start with it. Just 1 second. I had the opportunity to read this file there when we left here, and there is a letter tabbed 14, the file you gave us yesterday in the just look at the signature page. Was that written? Because I've seen letters from the governor, they have another signature.
This is the signature I put in a copy.
Sorry?
This is the signature I put under
copy.
Yes.
Okay. So we need to be sure, because you have this signature here, you have another signature here, and so on.
It's not my formal signature.
It's not your formal signature?
No.
Okay. So your people tomorrow will start exercising powers which the Constitution thought it wise to vest only in the governor and what? Deputy governor. The Constitution, if it intended to have it delegated, it should have expressly said so, that executive director supervision can do this, or the governor may. Because if you take that interpretation, you are going to have so many governors and deputy governors in the bank. And I hope this was not one of the case. I hope this was not one of the case. Somebody thinking she can be governor.
Mr. Chairman, we risk setting questions and answering them ourselves.
I think so. I agree. So, we may not resolve this issue now, but let the Bank of Uganda leave this boardroom knowing that powers vested in the governor and deputy governor are not casually transferable by any other law because they are constitution. That's number one. Number two, Governor, the law my colleague is citing, colleague as a lawyer, was under the Bank of Uganda Act, which was enacted before the coming into force of the Constitution, which created a new legal dispensation about the office of governor and deputy governor. And we never make these laws in vain. We make them to protect that institution and including the officers in those offices. Otherwise, people will start masquerading tomorrow that they have the authority and they are committing you, they are committing the bank, they are committing the country. Colleagues, can we close that and we go to the substance?
Mr. Chairman, we had asked some questions.
Please let the bank answer the questions.
Chair.
Let's just repeat the question and Honorable Andara's question, and we have that answered. Did Mrs. Vagenda, was she authorized to act in your absence in entering, disclosing that information?
No.
You see,
It also necessitated her to tell us who authorized her.
I have to thank the governor for a very bold answer. But he's the governor of Bank of Uganda, and whoever does things there, he's the sole supervisor. I just wanted to get from him whether if somebody commits Bank of Uganda without his knowledge and consent, it is not some incompetence on his part.
No, sir.
So, thank you again. Then who closed GTB and who sold it to the FCU?
But there's two issues here, Honorable Kasavante. We are looking at the issue of Section 40 first, that agreement, the NANE, the confidential and disclosure. After that one, we are now going to that cell, which is subsequent. So let's explore this one because it was before the cell. If we go there, then we lose out on this.
The last one is to Mrs. Vagenda.
But not on cell.
Yes, on authorization.
Disclosure and authorization.
Mrs. Vagenda, now that you never got authorized by the bank governor, who authorized you to commit Bank of Uganda into this transaction?
Thank you, Mr. Chairman. Through the governor, this question should be answered by legal counsel who drafted and passed on the NDA.
I don't want questions hanging. Let's finish this one.
Can I answer? Yes, Mr. Chairman. As I advised yesterday, we do draft agreements and pass them on to user departments. Even under the PPDA, the procurement department sends us document, we send them drafts to forward to the suppliers.
Mr. Katimbo, if you want to answer, we shall give you an opportunity.
To suppliers.
The problem, if you think you have better answers, just put up your hand, and then we shall ask you the questions.
Yes. The final draft, yes, would be produced by the legal department, and the final draft would have all the details in typing, in many cases. That was a draft, and yesterday I admitted that we are the ones who drafted it. That is true.
No. I think Mrs. Bajenda is asking a question. Who gave you instructions to draft it? I imagine a department will initiate a memo, so we are going to do a BCD, blah, blah, then do the legal document. The user department. Isn't that so? So, who gave you that?
Mr.
Because
Chair.
you're a lawyer, your clients are the different departments of the bank. Yes?
That's true.
They should be able to instruct you, say, we want to do a BCD, then you do your professional job.
Yes, that's true.
So, this particular agreement, who was your client? Which department was your client? Or which officer?
It was bank's provision. But, Mr. Chairman, I just want this to be clear.
Yes.
Even to the PPDD, all the clients, we can provide draft agreements. So, and as you know, it works. Yes, we can provide draft agreements.
Yes. So this was a draft agreement.
It was a draft agreement. It was a draft agreement.
Which ended up having signatures. Colleagues, I think it's not a matter we can push beyond this. But the point has been got. You see, let me, listen. We don't have the luxury of time. Once a point has been made, point of judgment of that point is not here now. It is at a time when we are meeting, going through the evidence. So, you've heard for yourself. Can we ponder over it? And then we shall make a judgment. Nathan, after that, I'm going to give you an opportunity now, but have that in mind, okay? So is Honorable Vyandara. Please, both of you have that in mind. Nathan and then Vyandara.
Chair, mine is on the law, Chair. Chair, as my colleague was saying yesterday, that the Bank of Uganda is not taking this committee very serious. You cannot come here and you fail to answer questions. Then in the morning, you come running with an act and you are reading for us exceptions. Legal counsel, I want you to answer these two questions. Question number one, from the act which you are reading the sections, can you read for us the section that was giving Mrs. Bajenda powers to sign that draft document? Two, can you also read for us a section that gives you powers to identify DFCU as the only potential buyer for Global Bank, just from the sections you are reading? You see, Chair, they assume we have never attended any class of law. You read for us those sections now.
Which sections?
The sections from the Act that gives Mrs. Bajenda powers to sign the document. And also a section in the Act that gives them powers to identify potential buyer as DFC only.
Honorable colleagues, the law, I think we have stated it as we understand it. The governor and deputy governor have got rights, powers, and obligations. Their mandate stems from the Constitution and any other law. but any other law should be read in light of the Constitution. We know who can commit a bank in contractual obligations. No, we know it. We don't have to debate about that. And we shall view that agreement, analyze it, and see whether it fits within the law. I'm sure by now the Bank of Uganda officials know our opinion. By now they know our opinion on who is authorized to act on behalf of the bank. Because we are not seeing any other law which gives any other person that authority. So that matter should be closed.
So, Mr. Chairman, we have been with our colleagues from Bank of Uganda for some time, and have been persistently seeing the direction they are taking. And last night's meeting, yesterday's meeting they held, coming with the interpretation of the legal counsel, grounds the whole thing. That though at the beginning we made it absolutely clear that you and us are here to make improvements, not to get culprits as the major objective. If anything was badly done, you just admit and say, yes, we have seen, we are sorry, but going around reading this law, they will not understand if we say this. I told you about the elections we held. Those people we defeated underestimated the voters. They would say anything. For us, we are telling the truth. That's why we are here. So please, let us not waste time on this. It has been very clear. There is no way, in my opinion, Madam Bajenda could sign this thing. And you also know it is true. But going around saying you shall confuse them, you will see. Please, we are here to make improvement. If something went wrong, we admit and say we are improving, we are moving ahead in a better way. I thank you, Mr.
Yeah, always you'll have to resort to Honobiandara for that. And I think the Deputy Governor is the one who said it yesterday. About about this challenge. He said yes, I think I was putting it a bit different, as a way forward. Conceding that actually yes, I think there was a problem there. He couldn't have said that, but that's how I understood it. He said, but as a way forward, we've taken note. It helps. It does help. Because then you would know that that challenge was made but in good faith. I don't know that you get it. Somebody will know, yes, I think they have realized they could have done it better. But if you go around and deny and try to find some justification and so on, then we start thinking that actually it was done in bad faith. And once we think it was done in bad faith, then we will resort to other ways of handling the issue. So if there is a challenge, let us accept there is a challenge. It was done orientation, but maybe it offended the law. That I would accept. That I would discuss with my colleagues and say, okay, this happened, done in good faith, but contrary to the law. I thought that's what we'd be doing, Governor, Deputy Governor. Colleagues?
This is a procedural matter.
Can I have that as the last, really? Today is Friday, I have Juma prayers.
Chair, two things here. One, I'm glad to note that there is a signing powers policy with the Bank of Uganda. Under the Bank of Uganda administration manual. And it's very clear. And the purpose, I think, was intended to streamline some of these challenges. But number two, Chair, as we closed yesterday, we had asked for some documents, and particularly for the list of the shareholders of DFCU. I thought we would have them to benefit our discussion.
Okay, now that you've talked about, as we closed, I'm sure that it was rated the query. So can we have that list? And then I'm sure it will be answering the query. Is it relevant, the query?
Yeah, it has to do, we're interrogating the choice they made over DFCU, and for us it was important to know the shareholders, maybe to arrive at the justification.
Shareholders of DFCU?
Thank you, Chair. Through the Governor. When we departed yesterday, there was a requirement for us to provide a list of shareholders of DFCU. Mr. Chairman, if I may, I would like to provide a little clarification. DFCU Bank is a wholly owned subsidiary of DFCU Limited. So DFCU Limited is the publicly listed entity. We have gotten the DFCU register as at 31st December 2015, 31st December 2016, and 31st December 2017. Mr. Chairman, under cover letter from the Governor, I would like to submit this to you. Second, there was a request you had asked for certain officers to be available today.
Yes.
Mrs. Sophie Iwumwe Chironde is here. Mr. Makei Owumo, who was the head of the on-site division, unfortunately is out of the country, but he'll be available on Monday. Thank you.
Who is here?
Mrs. Sophie Chironde.
Mr. Chironde, you are most welcome. Why we required you, you are one of the people who negotiated this deal with DFCU. Just sit near the Deputy Governor. It's not about protocol, so don't imagine you are going to be Deputy Governor tomorrow. Yes. What's your name? Repeat it. When did you join the bank?
Thank you, Chairman. And through the Governor, my name is Sophia Chironde Iwumbwe. I joined the Bank of Uganda on the 27th of September, 1999. I've been working in the Supervision Directorate.
What's your position now?
Assistant Director, On-Site Division, Commercial Banking Department.
Okay. Now that the issue we are going to speak is very controversial, I'd like to know whether the one we are going to talk about, whether you are actually saying the truth, nothing but the truth, okay? That is the only reason we want you to take oath, okay? Just to commit you to tell the truth, and can you just quickly administer a short oath to... Sorry? Short truth. A short oath. Please, please. Okay. You may even put up your hand. You want the Quran? Okay. We also mentioned Timothy. Yes? Timothy Sechirai, something like that.
Mr. Chairman, through the governor, when we went back and checked our records, actually Mr. Timothy Sechirai was never the on-site division head at the time in question.
He didn't have anything to do with this transaction?
Not that we are aware of, perhaps, unless he was working with Mrs. Bajen in some other capacity, but because the question yesterday was, she named the head of on-site division, and our records indicate that was Mr. Makei Oumo.
I thought she just mentioned those she thought she worked with. Those were involved in this process. That's how she mentioned this. But where is he? Is he still an officer serving in the bank?
Yes, Mr. Chairman.
Please, on Monday, come with him if he's not here.
I, Sophia Chironde Iwombwe, affirm that the evidence I shall give touching the matter before this committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Yes, Mrs. Chironde, you most welcome again.
Thank you, Chair.
Yeah. Tell us, what role did you play in the negotiation? First of all, in identifying DFCU as the buyer. How did you invite them? Tell us the details of the negotiations and why you took the decisions you took. Because the information which is here that you were part and parcel of this process, you took the decisions.
Thank you, Chair, and through the Governor. Chair, I did not participate in the negotiation, but I played a role in the closure process. And if you may allow me to describe the role that I played.
So, for purposes of the record, you did not get involved in the negotiation?
No, I did not. But I can describe the role that I played.
We are going to that.
In the whole
going to
process.
that. Did you play a role in identifying DFCU?
No, I did not.
Do you know who played that role?
I do not know, because, Chair, through you, my rank at the time was an operational rank. I was an examiner in charge.
Okay. Tell us then, what was your role?
Thank you, Chair. When the Bank of Uganda decided to place Global Trust Bank on a special monitoring process because of the precarious financial condition, my role as an examiner in charge was to draft weekly monitoring reports, which I used to submit to my supervisor, the head of on-site division at the time.
Who is that one?
Mr. Make Awom.
Make who?
Awom.
Awom.
Yes.
Is it the one who is out of the country?
Yes, Mr. Chairman. We'll be available on Monday.
So that went on, Mr. Chair. I do not recall for the period of time that lasted, but until a time when a decision was made to close the bank. Now, I was involved on the closure date, and this is what I did. I verified the accuracy of the numbers that were included in the P&A. Mr. Chairman, the P&A which was served to this committee has an addendum. That addendum has the value of loans and advances, deposits, government securities, and the list goes on. Now, I was involved in the verification of the accuracy of those numbers. We compared the balance sheet figures with the listing, and this we did between Bank of Uganda, DFCU, and the Global Trust Bank team. And all that happened on the day we closed the bank. Mr. Chairman, I want to submit. That is what I did.
Colleagues, you've heard what she did? Because the question is here, who was involved in this process? Because we want to know how the decision was taken, and your name had been mentioned. But to the extent to which you participated, you've explained. What more would you need from this witness?
Mr. Chairman, me, before the witness gets away, I wanted to ask Mrs. Vagenda whether she still maintains that she worked with the one Sophia Chironde in negotiating with the DFCU in the transaction of selling GTP. Now that you have heard from her.
Thank you, Chair. Through the Governor. Chair, you will recall yesterday I said I don't remember, and you allowed me to consult. When you allowed me to consult, Chair, I consulted the staff of Bank of Uganda. You recall I was given these names by the staff of Bank of Uganda and the offices. You recall, Chair, that I said Director Commercial Banking, Head of On-Site, and Examiner in Charge, and I was given these names.
Now, let's ask a specific question. Mrs. Vagenda, who other than yourself was involved in the negotiations? Who other than yourself?
Thank you, Chair. The Director Commercial Banking, the Head of On-Site...
No, just give us the names.
Mr. Chair, I don't recall at that time who was the director. I'm giving offices.
I'm just imagining I am the executive director and the people below me are my directors. And you want this committee to believe that you don't know who your directors were. You sat in a meeting, you planned, you negotiated with other people, and you don't remember the individuals, you just remember their offices. That's what you want us to believe, Mrs. Vagenda?
No.
Okay, now that it is not true, just tell us, who did you sit with and negotiate this deal? Who was part of your delegation, your team?
Mr. Ben Sekabira, I need to remember the EIC. The EIC is a junior person. Please, let my people remind me, please. She was the EIC Sophie, examiner in charge. Please remind me of who was the head of on-site then, because offices have changed, Chair. Who was the head of on-site?
You see, we are not here to look at offices now. We are looking at people who took the decision. You and Sekabira we know. And Mr. Sekabira, we have interacted with him for the last 3 weeks. So, this we know. This we certainly know. It's only you who has been away for some time, but now we are here. You and Mr. Sekabira, we know. Mr. Sekabira, may you confirm? One, that you and Mrs. Vagenda sat and identified the FCU. You and Mrs. Vagenda negotiated this deal. And then 3, who is the other person other than you two who sat and negotiated this deal?
Thank you, Chair, and through the Governor. I can confirm that I participated in the negotiations between ourselves and the DFCU Bank. I don't quite remember how the team was composed, but I was there and my supervisor, Justine Agenda, was there.
No, you two, there is no problem,
Yeah.
but who is any other than you two?
Possibly, to my recollection.
You see, don't take us possibly, most likely. It will not help. And we don't want you to mention somebody's name, and tomorrow we are calling him here, and he comes and gives the story like Sophie has done.
Chair, and through the Governor, I can confirm that I participated together with Mrs. Vagenda.
So,
You know, Mr. Sekabira cannot remember when he's in a crowd. He needs to be given time alone and think.
and you see, let me say this before even my colleague comes in, Governor and Deputy Governor. If you have meetings and there are no records, there are no minutes, it is just absurd. It's just ridiculous. Because you see, by now, somebody will be looking at the file and say, well, these are the minutes. It was 1, 2, 3, 4. But somebody says, we even destroyed the records. Just imagine that sort of situation. So we are here, the people don't know who are in the meeting, except these two. We can only come to one conclusion, that this deal was negotiated by Mrs. Vagenda and Mr. Sekabira, because we have no reason to think there was any other person.
Now, Mr. Sekabira can be of some good help. One, to tell us who assigned him that specific task. Madam Vagenda was like not forgetting, but you still work with Bank of Uganda. You could now help this committee, tell the committee who gave you that specific assignment of negotiating on behalf of Bank of Uganda. But 2, to Mrs. Vagenda mentioned the names like Sophia Chironde and somebody Sechirai Timothy. If that one could help you remember whether you ever sat with those in negotiating this transaction.
Thank you, Chair, and to the Governor. Work in the bank is by instruction. So if my boss says, come and join me in this meeting, I have to follow. I cannot say I will not be there. So that's the way we work.
Why don't you just answer the question?
I joined this team because I was invited by EDS then, it says just in the agenda, to be part of the negotiation team.
How many people were in that negotiation team?
How many people were on your team? Mrs. Vagenda doesn't remember except you.
Chair, I also don't want to say something that is wrong because
Remember
I'm
your
on
oath.
oath, yes. I vividly remember myself and Mrs. Vagenda.
What reason is there for you to remember Mrs. Vagenda?
And not others.
Why do you remember Mrs. Vagenda and not the others?
Chair, and through the Governor, it's because this was the chair of this meeting, and the meetings continued for some days. So, and she was my boss. So I cannot forget that we did this process together.
Chair, he says the meeting continued for some days. Did you ever see minutes being taken for those meetings?
I don't remember seeing minutes being taken for this meeting. meetings.
And which people from DFCU were in those meetings?
I remember the company secretary and the MD were always in these meetings.
So how were you reminded the points of discussion and what you could have come up with the previous day without any minutes?
Like practice has been, such meetings are not minuted. You discuss, you know where you have stopped.
Mr. Sekabila, you are selling a bank.
Mr. Chairman.
And you sit for days, no minutes, you are adjourned. Then the following day you come, come on.
Colleague, can I say something?
Yeah, we have to close this and move ahead.
Yes, because I want to say something.
Please do.
All this discussion will take place. Everybody will have to scribble somewhere. But the outcome of all these negotiations will be reduced to an agreement, which both parties would agree to and sign.
That is it. We are looking at how you even looked at, we came up with an agreement. Two, if you are saying everybody should scribble down something, that is the reason why you should have the minutes, because you know that you need some record. But let me say this to the Bank of Uganda staff, colleagues. This is not your personal estate. Once you sit in an office and you are in a meeting, it is government property. Those minutes are government property. They are Bank of Uganda property. That's why after it should be left in the office, and your successor eventually has to reflect on them. If you go away without leaving record behind, you go with the institutional memory. Common sense.
And Mr. Sekabila said...
Because can you imagine when you leave an office, your successor has nothing to refer to. Nothing. Like now an opportunity has arisen for you to say what happened. The governor is here every day, the deputy governor is here everybody is here every day, and you are saying, I don't remember, I don't know, Parliament is here every day. Why? Because the officers handled the matter very informally, casually, and was this in good faith? Are we going to accept that after this was done because of confidentiality? Or they didn't want to have a record at all? And why didn't they want to have a record? That will be interrogated and we shall come to a conclusion. General, we have to close this, but say something.
Mine goes to the Director RICO. This interaction, the negotiations, I think they took a legal direction. And that's the reason why you drafted the agreement. So, did you attend that meeting, the negotiations?
Mr. Chairman, and through the Governor, I thought the question was, who negotiated this discount?
Don't say
Did you attend the negotiations?
I attended the meeting that reviewed the contract, that reduced the agreed terms to a contract.
Did you attend the negotiations?
The negotiation of, I want you to, Mr. Chairman, I'm on oath, and I must say that when you say, did you attend the negotiations, we need to be clear on whether you're asking me whether I negotiated the discount or whether I participated in the negotiating of the contract, putting the terms of the contract in the agreement. Yes, we put the agreed terms in the contract.
Did you negotiate the terms together with Mr. Sekabira and Mrs. Vajen?
Okay. To be honest, I do not have a good recollection of. Yes, I do not. That is true. But what I remember very vividly, we prepared the contract.
That Mrs. Vajen has said.
Yeah.
But what we are asking, when you are negotiating the sale of those assets of the bank, coming to a price, inviting whom you are going to invite as DFCU, those meetings, did you attend them?
Mr. Chairman, legal department does not identify potential buyers.
No, did you attend any meeting where the potential buyer was identified?
I could have attended one.
You're saying, you see, Council, you first say that legal department does not what? Attend or participate in identifying of the potential buyer. Then when you put a specific question, they say you could have attended, which is a contradiction.
No, Mr. Chairman, that is not a contradiction. Identifying a buyer, like I've clarified, is not the mandate of the legal department.
Chair, my worry is one.
Negotiating a contract, the contract terms, please minus the figures, is not for the legal department. The department does not negotiate.
Who negotiated them?
Negotiating the figures, Mr. Chairman, as you know very well, lawyers are not figures persons.
I don't know anything. Did you or you didn't?
I did not negotiate figures. Thank you.
Yeah, my question still.
Then Nathan, and then Mike, and then we close this, please.
These negotiations. The negotiations are supposed to indicate the legal implication, and it's unfortunate that a disclosure was made. Illegally, I should say, because I think there was no authority. So, Director, why didn't you advise the superiors? Because you are the person who drafted the agreement, which was later signed into a full document. So why were there no pieces of advice to the executive director and her team on what would be the consequences of that premature negotiations? Thank you.
Nathan then should answer at the end.
Thank you, Chair.
Just note down the question which refers to you, then you can answer at the end and we summarize this.
Yes, Chair, mine goes to the examiner who was writing reports about those banks. Madam, in your reports and in your opinion, is it you who recommended the decision of selling the bank?
Thank you, Chair, and through the Governor. I would like to request the Honourable Member to repeat the question for me, because as examiner in charge, there is a report of on-site examination that you write, and there are these weekly monitoring reports that were instituted for Global Trust Bank. Honourable Member, I would like to be sure that I'm addressing the question. Which report?
Now, my question is, you are giving either weekly or whatever reports on the performance of those banks.
Yeah.
in your recommendation after assessing the bank, did you recommend that the bank should be sold?
Thank you, Chair. To the Governor, I would need to, I think, be very clear on what the weekly monitoring report was all about. This was a report to monitor the liquidity position of this bank, the movement in the non-performing advances, and a number of things which I may not remember now. I don't want to make a mistake since I'm on oath. And whenever I drafted this weekly monitoring report, it was mainly to do with the trend. Yeah. Now, honorable member, I could not have recommended a sale because that is not within the powers of an examiner in charge. But what you would do is to comment on the financial position, the trend, liquidity, and whether or not the depositors are now stable, and things like that.
Now, finally,
I submit.
Now, finally,
we need to move, gentlemen.
Yeah, finally, Chair. Now, from your examination, the decision which was taken, do you think it was a good decision? You know, Chair.
No. We shall ask those questions later. I think let that lie, whether it was good or not. Let's go to the issues, what role they played, and then whether it was good or not, we shall handle it later. Can I have yes?
Thank you, Mr. Chairman.
And then Mike, and then this is closed up.
Mine goes to Mr. Sekabira. And I need to remind him that his main duty was to maintain an even and impartial hand among all the persons whose interests were involved in the winding up and the selling and the whole process. I want to inquire from him whether he played his role very well and perfectly to help the people who gave him the work to do, since he was the most highly and experienced person to do that job as a liquidator.
Chair, I'm a bit confused.
I have not given the microphone. I think my colleague is asking whether, in your judgment, what transpired during the sale of GTB, you played your role. To use your words, what? Letty? Whether he played his role, but I want to use your very words.
Whether he played his role as a liquidator in the whole process.
Maybe when you are negotiating this deal, did you play your role well?
Chair, I did my job very well, and we resolved this bank.
Resolving, obviously, it will be resolved anyway. You see, resolution is eventually you resolve it.
Remember, he was partial.
Chair, this resolution did not cause any loss to a depositor. This resolution did not cause any loss to a creditor of that bank. This resolution did not cause any loss to government. So in terms of what we did, I think it was
we
a
are actually
perfect
going
case.
to examine, interrogate, and when you had already taken a decision to close the bank, you identify a buyer, you are negotiating, and you are busy asking the shareholders to put in money. Isn't that also correct? We are going to interrogate that. Here is, you've taken a decision, you are going to close this bank. You have identified a buyer, you are negotiating. And at the end of the day, you are busy telling the shareholders, put in this, giving them hope that actually they are going to have their business sustained and so on, and you are busy winding it up. We are going, because when you look at this file which you brought yesterday, I see the communication, and some signed by you. Even when they put in their plan, and the letter you reply, yet you are busy selling the bank. It's all here, the evidence is all here. So we are going to interrogate whether you acted, as my colleague says, fairly or ethically.
And Chair, to add on that, remember Mr. Sekabira is in charge of commercial banking, and whether he was doing very well to advise these commercial banks.
So this is the last question on this, and colleagues, after we go back to the Auditor General's report.
Thank you, Chair.
And please be brief.
I've just received, I was perusing the document submitted by the EDS in regard to the shareholding.
Which document?
Shareholders.
The DFCU register as of 31st December.
I don't know whether your colleagues are hearing you. Are you?
We requested for a list of shareholders. Chair, I would need to know, because I've seen that the Bank of Uganda Staff Retirement Benefit and the Bank of Uganda Staff Pensions Fund held shares in that EFCU. Is there a possibility that this could have informed your decision to sell Global Trust Bank to EFCU? Number two, Chair, in relation to the management now of Bank of Uganda.
Let's just... What scheme is that?
There are two schemes, the Bank of Uganda Staff Retirement Benefit Scheme and the Bank of Uganda Staff Retirement Benefit Scheme. They are shareholders of that DFCU.
First of all, do those two schemes exist?
Yes, they do, Mr. Chairman.
And is it also true that you are investors in DFCU?
Mr. Chairman, I would not know that, but we haven't have the director who manages the scheme, and also one of the trustees here with us, so perhaps they'll best be able to explain that. Or, if you allow me to ask Mr. Bakashara Ruhanga, he's the director of the pension scheme and currently acting executive director of administration.
Where's Mr. Bakashara Ruhanga? That means they ask the God. You pray to God.
Thank you, Mr. Chairman.
Yes.
And honorable members. Through the governor, yes, Mr. Chairman, as has been cited, we do have a staff retirement benefit scheme, and the scheme has shares in DFCU Bank. May I proceed to expound?
Expound what? You came knowing what we are going to ask you.
Okay, thank you, Mr. Chairman.
There are two schemes. Let's first, which one?
It is a retirement Bank of Uganda retirement benefit scheme.
Yes, and then the other one?
Mr. Chairman, it's the same scheme, but those portfolios are held by two fund managers.
Okay. Is it true that actually that scheme of Bank of Uganda is an investor in DFCU?
Thank you, Mr. Chairman.
Don't go into details of how much and so on. We just look at principles because some could be confidential. Is it true?
Yes, Mr. Chairman, it is true that the schemes hold investment in the bank, in DFCU Bank, but through the fund managers.
It doesn't matter whether through what, because you would know. You would know that actually our fund manager, because I'm sure he reports to you either annually so that the members know this is how their funds are being invested.
Mr. Chairman, with your permission, through the governor, the scheme has a trust deed and rules, and also the scheme is licensed by UBRA. Those particular documents stipulate the roles and responsibilities of the trustees and also of the fund manager.
Nobody is querying that. What we are looking at, is it true that Bank of Uganda staff has actually an interest in DFCU? So whether the rules, nobody is saying you offended any rules. But is it true?
Mr. Chairman, thank you. Yes, it is true, but it has to be put in context, Mr. Chairman.
Give the context.
The context is that the fund manager has the mandate, and the investments by the fund manager are done at arm's length, as provided for in the Act. There is an agreement, and the fund manager is provided with an investment policy statement which guides them on what asset allocations, but does not dictate to them where to invest. So just as the scheme has shares in DFCU Bank, it has also an interest in Baroda Bank, in Stanbic Bank, among others.
And that's where our problem is.
Yeah.
And let me tell you, before Mr. Katimbo, who seems to have all these reactions all the time, you are a regulator, and you regulate commercial banks. You go ahead and you invest in the commercial banks. And chances are that when you have a situation like this, there is a good deal coming, and you know that I have an interest in this deal, in case to go through, wouldn't that impair your judgment? Naturally, because eventually you are beneficial.
Chair, maybe we need to know whether the scheme was in DFCU before it took on to a Global Trust Bank.
At the time of the question my colleague is asking, at the time this decision was taken, were you a shareholder in DFCU?
Thank you, Mr. Chairman. Through the governor. Mr. Chairman, like I mentioned, we have two fund managers. One fund manager, who is Stanley, has been investing since 2008 until January 2018.
Answer the question. Answer the question. The biggest problem with you people, you come with your answers. So we shall tell them this. But we are not interested in what you have come with. We are interested in answering the question as they have been put. Can I repeat the question?
Please, sir.
At the time this sale took place, were you an investor in DFCU? Did you hold shares in DFC?
Yes, that's correct, sir.
We will have our own opinion about that. Yes?
Last question, Mr. Chairman, is in line with the management of the regulator and the regulated entity. In a particular, Bank of Uganda on one side and the DFCU on the other side. Chair, I'm giving particular reference to one of the board directors of Bank of Uganda, the names of Dr. William Kalema. Dr. William Kalema was both the chairman of the board of DFCU Bank from 1998 to 2007. Then he became a director up to May 2012, according to the website of Bank of Uganda. Then again he became a board member of Bank of Uganda from November 2012. However, Mr. Chairman, with me I have a board resolution of DFCU Bank signed on the 4th of July of 2014. And it reads as follows. In the Republic of Uganda, in the matter of Companies Act 2012, in the laws of Uganda, in the matter of DFCU Bank Limited, board resolution. At a meeting of the Board of Directors DFCU Limited, properly and duly convened on the 27th day of June 2014 at Kampala, the following resolutions were tabled, considered, and passed to enable regularization of the company's records. Resolved, the Board of Directors and the company confirm designations of foreign persons from the Board of Directors of the company, and among them is Mr. William Kalema. Number 2, the Board confirmed appointment of the foreign persons of the Board of Directors of the company, and in replacement, in addition to the current Board of Directors of the company. Delegation of authority, the Board hereby delegates authority to the company secretary and the managing director to put in effect the resolutions of the Board of Directors of the company. That this resolution be filed with the Register of Companies, and it is signed on the 3rd day of July of 2014. Mr. Chairman, this seems to suppose that whereas Dr. Kalema was appointed in May 2012 as a director of Bank of Uganda as a regulator, he ceased to be a member, a director of this commercial bank DFCU 2 years later, on the 3rd day of July of 2014. I am therefore asking 2 questions. 1, I don't know whether it's provided for that you can be both a director in Bank of Uganda and a director in a bank that you regulate. Number 2, in regard to the knowledge we have here, therefore, that Bank of Uganda entertained DFCU for purposes of taking over Global Trust Bank, wouldn't it be a conflicted position that you have a board member as a regulator who also serves as a director in a commercial bank, and the two enter into an arrangement outside the normal procedure? I thank you, Chair, and I beg to lay this resolution at table.
Okay, I think let's handle this way. 1, the governor and deputy will answer the principle. About the individual person, it's better when he's around. It's better when he's what? He's around, because we are going to ask him. But the principle, yes, without really referring to this person. Is it correct for a board member of the regulator to be also a board member of the regulated? I think that's the principle, yes. The details about this, colleagues, Mr. Kalema will be here and we shall ask him about it. But about the principle, is it correct? Is it okay?
Thanks, Chairman. Can I request Bank Secretary to come in on the board charter? Bank Secretary, please.
And please don't refer to Dr. Kalema. We just want the principle. Then the issue about his holding both offices, we shall put it to him because he's coming. It's fair enough and it's judicious. Yes, Board Secretary.
Thank you very much, Chair. Through you, Governor. The board charter of Bank of Uganda Board of Directors bars the Board of Directors to be directors of a regulated entity.
Which I thought should be fair enough. You can't hold both offices, but can we wait to interrogate that further when Dr. Kalema is around, whether what they have presented is true? As of now, that's the board charter, and I imagine that's what regulates your board. Mr. Twine? we've agreed we must finish Global Trust Bank before we adjourn. Go to 2.7.4. No, we left when we are about to complete 2.7.3.
I believe, Mr. Chairman, we have provided our explanation, and I believe your guidance was that you would review our explanation in light of our response.
Because now that even the examiner is here, why do we just explain this 821 million variance on loans and overdraft? The variance, colleagues, when you look at that table, the loans and overdrafts, the variances was 821 million. Top table. Who can explain that?
Mr. Chair, I can provide some explanation as to why there are variances in these numbers, and this explanation was shared with the Auditor General staff when they were reviewing this process at the Bank of Uganda. In my submission, I did mention that one of the roles I played was to verify the accuracy of the numbers. Now, when we went on the day this bank was closed, a general ledger was run and a balance sheet was prepared by the finance team of Global Trust Bank. But we went down to obtaining breakdowns of the loan portfolio, and in this case that will comprise the loans and advances. Mr. Chair, we established that the listing of the loans was lower than the value of loans and advances that had been reported in this bank's balance sheet on that day, meaning that the loans and advances that could be supported with files and all the relevant documentation was lower. I don't want, Mr. Chairman, to address myself to the 821 now because I would need to go back to the reconciliation, but at least that was the basis upon which there were variances, and that also is true, Mr. Chairman, for the deposits.
And if the figure is a little bit lower, it could be understood, but when you say variance of 821, it's quite big. So that's where we need really an explanation what happened. Because you are not talking about, look at, for example, savings account, I consider is 8.9. Current accounts 19 million. Fixed and deposits 181, which I think they explained yesterday. But this particular one of 820 is on the high side, and we really like to know what exactly happened of this variance.
Mr. Chair, through the Governor, I prepared a reconciliation which was shared with the Auditor General's team during the review process. I do not have it with me here, but I can go back to the, if permitted, I can go and retrieve it, the reconciliation that I shared with the Auditor General.
Auditor General, please.
Thank you, Honorable Chair. Bank of Uganda yes did share with us the explanation of the variance. However, we were unsatisfied because when you look at Article 1, the definitions in the P&A, it says that the book values shall mean the amount stated on the books and records of GTB as of the bank's closing or the payment date, as the case may be. Our understanding of that, therefore, is that the P&A was giving the position as at closure, and the inventory also provides the position as at closure. So we could not understand why there was a variance even after carrying out the inventory. Similarly, the auditors that carried out the inventory also noted the same variances and they remained unresolved.
That's quite for you. So.
Thank you, Chair, and through the Governor. I will still need to look at the reconciliation that we provided because, Mr. Chairman, I have evidence that on the day of closure, the loan listing did not tally with the balance reported in the BS 100. And Mr. Chairman, I want to give some either context or background to this. One of the major problems of this bank was inaccurate reporting. And because of that, Mr. Chairman, when we went to verify the numbers, indeed, on that day, the balances reported in the balance sheet were higher. And Mr. Chairman, that would therefore mean that the balances that were included in the P&A were only those that Bank of Uganda could verify as accurate.
Okay, I think to resolve this, you need to go back, do your reconciliation document, and when we reconvene on Monday, this weekend you'll have to work a little bit. We'll give you a few minutes with the auditors to have that reconciled, okay?
Okay, Chair. Thank you.
Colleagues, as you can see, the variance of 821 million is not something you can, it has to be explained to our satisfaction.
But Chairman, what I'm failing to understand, Sophia was saying these were persistent, what were you supervising then? Because I thought Bank of Uganda is supervising those banks, and this thing goes on and on and on. What is the problem?
Thank you, Chair, and to the Governor. The Honourable Member is asking a question, what were we supervising then? Indeed, we are supervising this bank. And how the process works...
Actually, we've invited all the former directors of this defunct banks, all of them. They should be here next week. We've tentatively thought latest by Wednesday you people should be gone. And we've invited them, and this particular sent an email I think yesterday to my office that they are flying in from West Africa or something. So, Nigeria, yes. And we're going to ask the same question.
Yeah. May I proceed, Chair? Because I was explaining.
Summarize it.
Yeah. How the process works, after an on-site inspection is conducted, there will be key supervisory concerns that are identified. And what we do, we issue corrective actions to these banks. And Mr. Chair, I want to confirm that we were supervising Global Trust Bank just like any other and issue corrective actions in the reports of examination with clear timelines within which to address those issues. But as you know, as a regulator, you will not be in a position to determine or decide what a manager of a bank chooses to do. But in terms of executing our role, we supervise, identify concerns, and issue prompt corrective actions. And that we did, Mr. Chairman. I submit.
We shall examine that whether a correct decision was taken at the correct time, or it could have been taken earlier, or we shall examine that. To Mr. Twin again.
Thank you, Chair, through the Governor. I do believe at this time then we should turn to 2.7.4.
Yes.
2.7.4, the management of the assets in escrow. That's on page 29.
Have I identified the query?
Yes.
Go straight to it.
According to the monthly collection report from DFCU, a total of Uganda shillings 6,297,4,097 has been collected as at December 2017. 65% of these collections, amounting to 4,093,052,663, has so far been recovered and transferred to the Global Trust Bank recovery account in Bank of Uganda. The balance of 15,133,197,298 was yet to be recovered. Mr. Chairman, our response to this matter is this particular query refers to assets in escrow that were managed by DFCU Bank, that was appointed, that on top of buying Global Trust Bank, was also appointed to collect on behalf of Bank of Uganda. So far, Bank of Uganda has recovered 6.3 billion, as is indicated here, out of the initial 21.4 billion, and the recovery efforts are ongoing. So the query here is that this money remains yet to be collected, and our indication is that it is ongoing.
How do we know that it's ongoing? Do you receive reports from DFCU updates, and where are they? I thought what you do to answer this query, you say we have so far collected this, there's an ongoing process, and the reports we have been receiving from DFCU to show that actually this process is what? Ongoing. You give us evidence, and then we see whether we drop or somehow think this query is still relevant.
Mr. Chairman, the Auditor General was shown reports of quarterly reports.
Once it reappears between, then you have to bring it here. Because how do we know, for example, us as a committee, that the recovery is still ongoing? These are the challenge DFCU is what? Is facing. How do we know?
Mr. Chairman, I concede we shall bring that for you, just to confirm. But the Auditor General, Mr. Chairman, if you allow me, the Auditor General was shown these.
He wasn't satisfied, that's why he carried it here. If he was satisfied, he would not have carried it in the report. So at the exit meeting, he should have raised it, and he should have realized, then it's okay. If you are not satisfied, we shall carry it to the committee, because that's what happens.
Mr. Chairman, the fact of the matter is that money remains uncollected.
Do we still have to have a conversation about this, or to do what I'm telling you and we proceed?
Chair, maybe we could also get a valuation of the portfolio that was recovered, and maybe we could also find out, is the 6 billion outside the 30% commission that is supposed to be taken by DFCU? 35%.
Mr. Chairman, in response to that query, if we go back to the statement, it indicates that 65% of these collections, amounting to 4 billion, has so far been recovered and transferred to the recovery account, and this much was acknowledged by the Auditor General. I think the issue here is the 15 billion that is yet to be recovered.
What I am asking, out of the 6 billion that is recovered, is the 35% commission paid out of that?
Yes.
Or is it already paid?
Yes, Mr. Chairman.
First of all, even the commission of 35% is quite high. Can I have the basis for this? 35%.
The Office of the Prime Minister, in partnership with the Youth Go Green, presents the second SDG run to take place on Saturday, 15th December 2018 at Kololo Ceremonial Grounds, starting at 7 a.m. The theme, Youth Propelling SDGs to Fulfillment. The chief runner is His Excellency Yoweri Kaguta Museveni, President of the Republic of Uganda, accompanied by Right Honorable Speaker of Parliament of Uganda, together with United Nations Resident Coordinator. For participation, call or WhatsApp 0701 030673 or 07